court has been provided a motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense. State, I don't think we can have a hearing on this without JICS.
Welcome back. So today we have a lot of stuff to get through. A lot of stuff. Just forewarning everything, there's going to be a lot of commentary, there's a lot of documents to go through. I moved through it slowly. This video took several days to do because life and work, and I just had to chop it up. So sorry this came out so late. I'm sure there's a bunch of videos on this already, but now I'm here. Yay. So this is going over the most recent documents, picking up from the last hearing and what went down there. In the last hearing, Sarah Boone submitted a motion for Judge Kranick to view. Judge Kranick said we can't even go through this because she had not sent it to JAC first. So she has to send this to JAC, then they have to respond, then they can have the hearing. So we're going to go through those documents. Then they released the behavioral records from IMS, which is where they were logging when she picked up the laptop, when she returned it. So we're going to get into that. And then, towards the very end, I thought I was going to be finished with this. Now all the lawyers want money. All the lawyers are filing claims because the JAC is not running them their coin, and they have words to say about it. So we're going to read said words. Buckle down, get you a drink, get you a snack, get you a tasteful morphine drip. Do whatever you need to protect yourself as we dive into more and more case documents in this shit show of a trial that hasn't even started yet. All right, August 14th, 2024. In the Circuit Court of the 9th Judicial Circuit in Fort Orange County, Florida, the state of Florida, case Sarah Boone, motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. Comes now the defendant, Sarah Boone, by way of pro se, respectfully moves this honorable court to enter an order authorizing the state of Florida to incur costs of the following discovery expenses. 1. Reasonable fees for a neuropsychologist. These services include the reviewing of documents and physical evidence, writing of reports, travel, and trial testimony. As grounds, the defendant states the following. A. Defendant is charged with second-degree murder. B. The defendant has been adjudged indigent for cost. Broke. C. Defendant has no income and cannot afford the services of a neuropsychologist. Double broke. D. A genuine issue exists related to this case, which will require the assistance of an expert witness in the field of neuropsychology. E. Defendant is without funds and does not have the ability to pay the cost associated with an expert witness to assist in the defense of this matter. Therefore, she requires the assistance of the state of Florida to guarantee protection of her right to the process and effective assistance of counsel. You don't have assistance of counsel. Anyway, triple broke. So she said that she's broke 3 times in the first 5 points. F. Counsel has contacted neuropsychologist Dr. Hyman Eisenstein. G. The defendant intends to engage the services of Dr. Hyman Eisenstein. Dr. Hyman Eisenstein graduated from the University of Chicago Division of the Biomedical Sciences, the Pritzker School of Medicine in 1982. He works in Miami Beach, Florida, specializing in psychology. H. Defendant seeks permission to allocate funds for Dr. Hyman Eisenstein's services at a rate of $300 per hour for all work performed on the case except travel time billed at $125 per hour with an initial cap of $15,000. Oh my gosh, you were doing so good, Miss Boone Esquire. Oh gosh, this was so good. You were doing so good. And then we get to $15,000 cap. Be reasonable. Mr. Billy Lane has a $10,000 cap. Come on now. And even the $300 per hour, okay. The $100 per hour for travel, okay. $15,000 cap. There's not that much to do in this case, nor is there $15,000 worth of time to do all the things that you need to get done before trial starts. But I'm not mad at that. I'm not mad at that. She's doing really well so far. plus reimbursement for all reasonable and necessary related expenses, including but not limited to travel expenses. You already said that. Lodging, meals, mileage, that's also travel, postage, shipping, and document reproduction, and is a service provider with the JAC. I, defendant cannot properly prepare for trial until expert analysis is complete. Well, then you are out of luck. If you are waiting to prepare for trial until after expert analysis, that means you have to wait to get the funding. You have to contact the doctor and say, "Hi, we finally got the funding. Can you do this?" Cool. When can you meet? You have to schedule the meeting. You have to, in your initial meeting, that's when you'll finally go over what tests they can perform, what tests you need, because they're not just going to show up and do everything they have. So they have to evaluate you. And then from that initial evaluation, they have to see what else they need to do, which may take more time, may take more scheduling, more tests. All the while, your time is clicking down. You better prepare while in the meantime trying to get this, but this whole cannot properly prepare. That's what she says about everything. She can't properly prepare without a classroom, without hard copies, without a laptop with internet, without. Let's pause, side tangent real quick, because everyone, these comments are annoying. And even I'm hearing other channels talking about you have to have internet, you have to have internet to defend yourself. Y'all, the internet is less than 100 years old. Law and courts are not. We have done law without the internet for centuries. Yes, the internet is very important now, and we have new advancements and all these things, but these are not requirements. You do not need the internet to look up case law. You have a case law library. Normally, they have access to a law library of some kind. At least they have books that do have case law in it that she can reference. So it's not like she doesn't have anything. It just means she has to read. Yeah, the internet thing really gets me. You do not need the internet. You do not need it. You want it. You would like it. You would be way better because of it. And you would do better because of it. I understand that. You do not need it to defend yourself. And if you have forfeited your right to counsel and you have forfeited other rights and resources because of your conduct, we do not need to backbend, cartwheel, double back handspring, jump into a triple double layout punch front in order to make her satisfied because she will never be satisfied. So you need to properly prepare for trial on your own and then get these other things in addition. I'm not mad at this. This was just a side thing, but you can do other things to properly prepare for trial besides waiting for expert analysis. Because the other thing is, she's not just waiting for expert analysis, she's waiting for the analysis to say what she wants them to say. Remember, in the past, her attorney said that they can't use certain expert witnesses because they did not agree to say what she wanted them to say. And so then she threw a fit until they would. And that's probably why she needs $15,000 because no one's going to do that for a reasonable amount of money. But if you fill my pockets up, I'll lie for you. That's what most expert witnesses are. I have my own issue with expert witnesses. They kind of diminish all of it. They are very crucial and pivotal in court cases, and many court cases can be won and lost off of expert witness testimony because as a jury member, you're saying, "Oh, they're an expert, so they know what they're talking about." And because they told me their credentials and they're telling me this narrative, it must be true. That is not correct whatsoever. A lot of times, expert witnesses can be bought and sold. You can have the same substantive issue, get two equally qualified expert witnesses, and have 100% opposite opinions. And that can happen just naturally, but also you can definitely buy your own opinion. So, whatever, expert witnesses, they're useful for some people. Personally, they annoy me. I understand why you need them, but whatever. J, tangent over. J, defendant has attempted to request this evaluation through her previous appointed attorneys without success based on several factors, to include the attorney not being able to locate the proper specialist in this field of neuropsychology, the willingness of the neuropsychologist to work the case, ding, 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 and the authorization of the JAC to pay for said neuropsychologists. So breaking that down, you're not finding the right doctor who's going to say what I need them to say. You're not finding the right doctor who's even going to agree to my case due to the publicity and just how bad the case is in general. And even once you do find the expert who is in the field and will do my case, the JAC will not pay said neuropsychologist, which are all valid. I'm not risking my credibility as a doctor that I spent over 12 years getting all these accreditations and degrees for, just for you to have me make a fool of myself and lie for you. Now, K. Defendant believes that her pattern of behavior stems from a lifetime of mental and physical abuse and believes that she cannot have a proper defense without a neuropsychologist who can evaluate her exposure to this trauma. How do I feel about this argument?
No.
No, I don't like it. Nah. I get it. I get why she needs to do it, but sorry, you being mentally and physically abused throughout your life is not enough to tell me why you zip someone in a suitcase and film their last moments, taunting them. I don't think a neuropsychologist will be able to justify that one for you. A neuropsychologist specializes in understanding the relationship between the brain and behavior. Given the complexity of the defendant's mental health history, it is critical to assess her cognitive functioning and mental state to determine how these factors may have influenced her actions. Okay, so she's saying I didn't kill him because I was abused. That's why isn't she not talking about alcohol? Like, I thought she was going to pair this with the alcoholism. Obviously, I understand alcohol is not a defense. It's not a defense in Florida. Alcohol consumption and past prior alcohol consumption is not a defense in Florida. However, that does not mean it cannot be brought up to support a different argument. And this neuropsychologist is a path that is a little stronger. So if you want to tack on this and say, I have all of these traumatic disorders because of what I've gone through in my life, coupled with abuse of substances, which happens to be alcohol in this instance, led to her impaired judgment, diminished capacity, and ability to understand what she was doing, etc., etc. So you can reframe the argument of I was drunk in a different avenue. Still won't work, but you can introduce alcohol into the equation that way a little easier than just saying, sorry, I got drunk. Poor George. But she wouldn't even mention his name. She's going to actually have to during the trial, which is going to be shocking. And I honestly, I hope the prosecution does bring up whether or not she says his name or not. I don't know. I will be interested to see how they bring up her referencing George throughout the trial or not, and how she talks about him, because they definitely have been remembering that and they definitely have opinions on that, even though they haven't said it so far. Another thing that's really going to make me laugh is when the state flips on her, because right now the state is being very nice and trying to help her and trying to be understanding and accommodating with her, doing all these things, having these motions on their own, figuring out solutions behind people's backs, but not telling the open court. And that still makes me mad. If you don't know the mini rant I went on Mr. J about last hearing, here, Linda, roll the footage.
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own.
I'm sorry, what? You've decided to do this on your... For fuck's sake, Mr. J, why didn't you open with that? Why are we 40 minutes into my runtime right now and we are... You could have just said at the beginning, hey, Miss Fugate, pause real quick. We're gonna fix all of this, right? We're not even gonna do it. We're not even gonna have the court date because we're gonna do it on our own somewhere else. Why didn't they do this to begin with? I have to walk away. I have to walk away for a second. Oh my God. So I was a little heated, to say the least, and I understand. And there was actually a comment, I'm sad I forgot the comment, I can't find it anymore, but that talked about the importance of having the news media motion continue, even though the topic was moot at that point. And I'm half inclined to agree. Also, I wish that it didn't happen altogether and that Jay did just jump in and say, "Hi, we don't need to do this at all. We can just move this on. The media won't be involved in what we're doing anyway." So next. However, the comment did reference how it's important for the media themselves or to have a very coherent media argument on the record in order for her to not be able to bring that up on appeal later about cameras in the courtroom in general during the trial. So now they have a representative and a legal argument on the record from a professional arguing for the news's presence in the court. They won their motion. So moving forward, if he denies her request to keep media out for any kind of reason, or if she complains about media for any kind of reasons, media's presence for any kind of reasons, then there's already a legal foundation on appeal that would kind of squash that to a degree. Or she would have to address the arguments that were made there and still prove why her issues were unfair, unconstitutional, what have you. So, yeah, sorry about that little tangent. Where are we now? Wherefore, the defendant Sarah Boone, by way of pro se, respectfully requests to this honorable court, in conclusion, for the payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. Oath. Certificate of service. Sarah Boone. Sarah Boone. Okay, so this might be or is the best motion Sarah Boone has ever written. The best letter Sarah Boone, Sarah Boone, the best letter Sarah Boone has ever written for her case. Why? Because it's actually talking about her case. This is the first time she has written a motion specifically regarding her literal case defense. Everything else has been give me the discovery, give me more resources, give me more internet, time, access, give me these things. Now she's actually, give me a lawyer, da da da. Now she's actually asking for something for her literal defense, the actual defense itself that she will have to present in front of the jury. You don't get to go to the jury and say, they didn't give me internet. They didn't give me access to a classroom. They tried to put me in a cell for 23 hours a day because I complained and wanted every single thing my way. So they said, okay, cool, take the cell bid. So she is finally making an argument for her case, for her literal case and defense, and she's going to blame it on past traumas. It's not going to work, not at all. And it would be different depending on the nature of the killing, honestly. Like if it were a quick, swift crime of passion, still could be second degree murder, but this was long, prolonged, drawn out, torturous, heinous. She showed no remorse, no understanding of how cruel and horrible it truly was. And I want her to have to hear the ME talk about all of this, about how this would feel, how his death actually occurred, the evidence of the injuries that were left on him caused by her or her actions. And she's still not going to take it in and see it as her issue. She's going to take it in and try to think, how can I blame it on him? How can I spin it and blame it on anyone else but me? And I understand why she needs to do that mentally. But if she had the awareness to understand, okay, I'm cooked, there is almost a 0% chance that I actually get away with this and get away scotch-free. She can get a lesser included or maybe argue best case scenario, she gets a mistrial or a deadlock. I don't see that happening in the world ever. But this just shows, I don't know. I low-key think Sarah might be playing a 4D chess kind of move. Not intentionally per se, or not as elevated as it might seem. It's pretty obvious what she's doing, but the nuance there is very clever. She's trying to distract, right? That's always been the key. She is trying to distract from George as much as possible. I've said this in the past because the more you look at George, the more you look at what happened to him, his life, his actions, the worse she looks. Whenever you look up the abuse allegations she claims and talks about, and you look into George's past, they do look bad. And then when you look into the context of it, it looks messier. And then when you look into the context even further, you're like, oh, so there's this whole abusive past committed by you, Sarah Boone, that you were just never going to mention. And so things happen to you and not because of things that you've caused. Sorry, I'm going on a million tangents, but then this is another tangent. This is called locus of control. You have an internal versus an external locus of control. An internal locus of control, you are saying, I control the outcomes of my life. The good and the bad comes from me. An external locus of control, you're saying things happen to me in life, whether it's good or bad, depending on the context. I didn't do this to myself. The world did this to me. And having a balance of both of those is what you really need. You need to know what is truly your fault, what you truly could have controlled, and what outcomes that you did create versus what outcomes happened to you, what situations you were put in. Those things are both real in lives. And what we find an issue in is when we anchor ourselves in one or the other, when we see ourselves as the only ones making the decisions that we are the reasons that we are successful or bad, or if we believe the world is the only reason we succeed, or we believe the world is the only reason that anything bad has happened to me. Sarah Boone has a humongous external locus of control. Everything happens to her. She does not take responsibility for any outcome she caused herself. And you see that all over this case. So her external locus of control, rampant. She is saying she's going to point the finger at every living thing imaginable to say it is their fault that I zipped him in a suitcase and watched him die. And she's going to have to tell that to the jury. And we'll see how that goes. Sorry about that tangent. Anyway, moving on to the JAC's response to the motion. Justice Administrative Commission's response to motions for payment of cost and appointing neuropsychologists. Comes now the Justice Administrative Commission, JAC, by and through the undersigned attorney, files this response to the above cited motions as follows. 1. The defendant is seeking authorization for $15,000 at a rate of $300 per hour services and $100 per hour for travel for specialized mental health expert. Based on JAC's records, the court previously authorized $3,000 at a rate of $200 per hour for a defense mental health expert. So she wants 5 times that amount. And she put reasonable in her motion. I want the reasonable cost. And by reasonable, I mean 5 times what you previously authorized. The $300 versus $100 an hour, I don't mind that too much. It's okay, what it is. 3,000 versus 15,000, good Lord. 2, JAC may only pay for due process costs pursuant to section 29.007, 27.40 and 27.5304 to Florida statutes. 3, as directed by section 27.425 Florida statutes and the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract policies and procedure. Bold, JAC objects to any compensation rate in excess of established rates. And that's why they couldn't get an expert to begin with. No one is going to do what she wants them to do for that price. And I don't blame them. That is so much work, especially just talking to Sarah Boone throughout the course of a trial for a measly $3,000. Nah. 4, the rate of a psychological examination is a flat fee of $350. For other, that's pretty low. That's pretty low. For other services, the established rates for medical doctors and psychologists are as follows. A, in court testimony, $170 for first hour or less, $170 per hour thereafter. B, waiting to testify, court, $85 per hour. Good for you, sitting there making money. C, waiting to testify, deposition, $72.50 per hour. Travel time, $72.50 per hour. E, out of court call services, $160 per first hour. $160 for first hour or less, $160 per hour thereafter. 5. The defendant has the burden to show the particularized need for an additional mental health expert. The defendant needs to show the services of the expert is necessary for the defense of the case. Yes, and she started to do that, saying she has a history of abuse and that needs to be explored, but she needs to get more specific. I know she doesn't want to because she knows that telling that to the judge and uploading it means that we're going to see it. But to win the money, they need to know why. I don't need to know that you just have background issues. Everyone has background issues. I need to know why. Specifically, my pattern of blank kind of abuse, where blank happened, and blank kind of conditions require the necessity of a neuropsychologist who specializes in blank. She is giving too broad of reasons right now, but I'm not going to fault her for that. She tried at least way more than what she's done in the past, but she does need to do more for the JAC to accept it. And another thing, some people might think that the JAC or the court or everyone else is being mean to Sarah. No, they're holding her at the same standard. They gave her the pro se packet, which I think is why this motion looks so much better than the rest of it. Either that or she's getting some legal help by someone else. Who else? Who cares? But they still have to hold their standards. They can't just say, oh, okay, this looks better. You kind of got it. So we're just going to go ahead and give it to you because then everyone could do that in the future. No, they have to hold the standard and they are being more, I think, giving more leeway here and there. So, 6. As enunciated by the Florida Supreme Court, a party seeking due process costs has the burden to establish 1, the particularized need for the due process services, and 2, prejudice arising from the denial of the due process services. Yeah, because she didn't explain how denying that would create prejudice. And I don't think it would. I don't think it would. Unless she had like a serious condition that has, been ignored completely or that is crucial to this case. But no condition is crucial to this case based off of what happened. She sounded very lucid, not lucid. She sounded very coherent, even though belligerent. She sounded together, if that makes sense. She knew what she was doing the entire time, and she was able to do it. Man, the second she opened that video camera, she sealed her fate. And I'm glad she did. I'm really glad she did. Because she could have gotten away with this. She could have talked this away, but because she is who she is, and she has to control a narrative and has to keep enunciating and repeating certain plot lines again and again and again, she's in this position. 7. The determination of whether to appoint an expert is within the broad discretion of the trial court. Quote, an indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and that denial of expert assistance would result in a fundamentally unfair trial. I don't think she can do that. I'm trying to think of instances where that would be. And I don't know. I don't know off the top of my head, but yeah, unless you had just like a complete mental break or something, and it's obvious through the case facts that you have to take that into consideration, or else you would be completely flawed and not seeing that. The only thing I can think about is there was that one case, maybe it was also in Florida. I can't remember at all, and I don't feel like looking it up. But he basically had a completely mental breakdown and killed 2 people and started eating their faces or something like that. And he was like a younger kid, and so he was actually found not guilty by reason of insanity and, sent away to an institution forever. Which, side note, people who claim insanity defenses always make me laugh somewhat. The insanity defense is when it's not legitimate at all. Legitimate ones I get. But going to a mental institution is not any better, really. I mean, it's different, but there is no set out date, honestly. When you go behind institutions, you do not have to get let out. If they think you are a danger and that you have not been reformed and that you can be a danger to others, they can keep you in there indefinitely. So while it sounds like a better option than prison, sometimes you can have, oh, this is going to be 5 to 10 years in prison. You have a start and an end date. When you go into mental institutions, that end date is never guaranteed. We can say you go in for 5 years, but when that 5 years hits and they still deem you not medically competent to leave, you stay. Just putting that out there in case, people want to plead insanity. Depending on the crime, just do the time. 8. The defendant also has the burden to establish diligent efforts to obtain services within or closer to the rates established by law, assuming the defendant establishes the particularized need for a specialized mental health expert. The rate sought is consistent with the rates authorized for similar experts in other cases. Yeah, so she has to show that one, she tried to find an expert within the established cost and why it is so necessary to pay for an expert who exceeds that amount of cost. And Bankowitz, I remember he said in court that he was still trying to find an expert because they would not do it for the agreed rate from JAC. Understandable, these numbers are not great. The JAC, it sounds good on the surface, and then, sometimes they be getting wishy-washy with me. They feel like an insurance company. So they're going to nickel and dime you for anything, really. And you're going to have to justify every nickel and dime. 9. If any providers desire direct payment, the JAC's procedures require the vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain payment. 10. JAC does not request to participate in any hearing set in this manner. Should the court desire JAC participation, JAC requests to appear through communications equipment and can be reached at toll-free. They said, we do not want to be there, but if you force us, we will Zoom in, Skype us in, whatever, if we must. Because I guess they're assuming that Kranick will reject it, but honestly, I think Kranick will call them in. I do not think Kranick will not allow the JAC to be there. He is going to want on the record for the JAC to tell her why they are denying her. That way he can deny her. Because if he doesn't have them there and he just goes off of the written motion, she would throw a fit and say, you're doing this because you hate me. Wherefore, the JAC requests, should the court grant the defendant's motion, also include in its order the specific due process services authorized, as well as hourly or per unit rates and maximum fees authorized, and that the provider be paid in accordance with rates, terms, and conditions set forth by Florida statutes and the JAC contract, policies, and procedures. So they're saying if you grant the defendant's motion, the judge needs to include in its order specific due process services. So the judge needs to determine what services they will actually approve, and make sure that they abide by the JAC's rates. I guess Kranick is going to ask her, why do you need the expert witness? For what test are you looking to see to get? And she's going to say, well, I was looking to meet with him once I got him, and then we would figure out what tests we need, and then we would do those tests. No, we need that up front. You need to tell me why you need them because of X specific reason for X specific test, and how much they will cost, and make sure that it is within their established guidelines. These are the rules you follow when you are broke. Okay. So I don't want to hear her fighting back on this too much. They were pretty nice in this response. They denied it, but they gave the reasons why, they gave the appropriate rates so that if she wants to search for others, and in that pro se packet, it has a lot of different names, I believe, and information that you can search for different types of experts. There is one last doc I wanted to go over as like a little dessert, extra bonus, whatever. And this is a notice filed with about, I can't speak. Oof. Basically, this is the record of when she checked out and returned the laptop. That, remember, they said they were going to log every time that she takes it and every time that she returns it. And so I want to see, did she check this laptop out for every single hour and minute that she has available to her? Because she better have, for all the complaining that she is doing about everything. If she's going to try to bring this up on appeal, I need her to have checked out that laptop for every single minute. Now let's see. August 6th, 2024 at 10:36 p.m. On August 6th, 2024, laptop, thumb drive, discovery hard drive issued to inmate Boone. Oh, so she picked it up at 10:36 a.m. Remember, she has it from 8 a.m. to 4 p.m. every single day since that order was released. So she picked it up at 10:36. That means 2 hours and 36 minutes were missed. I'm going to try to keep a tally and run this up. Then it was returned same date at 4:13 p.m. See, so it looks like they're not snatching it away from her exactly at 4. So she turned it in 15 minutes late on August 7th, the next day, 8:30 a.m. So she took that out 30 minutes later. So that's an extra 30. If you can hear me writing it down, sorry, but whatever. August 7th, 2024, 2:52 p.m. Inmate verbally refused breakfast. See, she gets mad in that letter of like, why do people know what meals I have? Because of this, when you refuse things, they have to take record and write it down. And then you're mad when that record is posted. Don't refuse breakfast. Just go to breakfast then. You don't have to eat it, but I get it. Just don't be mad when they have to write it down. So then August 7th, at 6:11 p.m., Boone returned laptop USB drive at 1600 hours. Okay, so this was just written later, but she turned it in at 4. All right. August, gosh, why am I so bad at this? August 7th, 2024, 10:22 p.m., inmate Boone Sarah was called out for an attorney visit in FDCB dorm. Y'all can get attorney's visits at 10:22 p.m.? I did not think y'all can get that late. Inmate Boone stated, "No, I don't have an attorney. I had too many random people coming to see because of my case. I took the paperwork from the attorney and delivered the paperwork to inmate Boone. I wonder why. I wonder why people would be coming to see you, inmate Boone, regarding your case. Why other attorneys specifically would be there." Anyway, August 8th at 12:11 a.m. Okay, so midnight. Inmate Boone was advised at approximately 10 that she had an attorney visit. Inmate Boone requested to know who the attorney was, being that she has no attorney assigned to her. Inmate Boone said that she does not feel comfortable visiting anyone that she doesn't know because crazy people have been reaching out and scheduling visits with her, claiming to be someone they are not. I wonder why, Sarah. I wonder why you would have random quote unquote crazy people showing up pretending to be a lawyer. I wonder why. Okay, is it here? Is it? Oh, it's here. No, 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 no. Oh no. Ooh. Inmate seeks attorney. Oh, what is this? This is a flyer. She's looking for a new lawyer by flyer. Um, Whoa, this is so useless. She wasted so much time, so much paper, so many pens. Orange County Corrections Department. Invest in the invest in the oppressed. Believe. Maybe don't put out a stupid circus ad, freak show, help wanted poster asking for any lawyer to fulfill a million requirements that no human alive could fill. Maybe don't do that, and you won't have, quote, crazy people knocking on your door at 10 p.m. That's crazy. Inmate Boone was notified the attorney's name was James Waxinski. I'm really sorry. I genuinely am sorry if I messed that up. Um, However, due to inmate Boone delay in response on whether or not she wanted to meet with him, he dropped off her case files and departed. When inmate Boone was given her files and notified of the attorney's departure, she began to remember who he was and became upset, of course. Inmate Boone mentioned that she has met him met with him previously and that he traveled from Tallahassee just to meet her. Well, then you should have met with them. That is so annoying to me. That I hate that so much. As if the officers, the guards, are supposed to know who any of these people are. So you have someone who came to meet you. I don't want to meet anyone I don't know. What are you talking about? I met with him before. He came all the way from Tallahassee to see me. Grr, grr, grr. You took too long to say yes, and he left. Understandably so. Who's going to sit there and wait? Anyway, it was explained to inmate Boone that we are not responsible for his departure. Exactly. She was notified of his presence, and her delay in response resulted in his departure. Sergeant Moreno was made aware of this information. This is for documentation and informational purposes. Okay, so I think, yeah, these are both the same incident, even though it's on August 7th and August 8th. They were only reported a few hours apart from each other. So whoever this James guy is tried to visit her. She took too long to respond. He said, "Here, take some files. I got a dip." Maybe this James guy is why this motion doesn't look horrendous. Well, let's see. This happened on August 8th. Her motion was on August 14th. So yeah, this happened beforehand. So hopefully this whoever James person is has helped her gain some sense. Um I know there's like rumors that some YouTube lawyers out there are trying to help her, which, I don't blame them. Who really cares at the end of the day? If they want to help her, let them help her. Honestly, it's not going to make any kind of difference or at whatsoever, like at all. They can help her not embarrass herself as much, but they're not going to get her off. And I don't think even the YouTube lawyers I heard of, I don't know, I can't speak from any authority on that, but I don't think they think she's innocent, but they just think she still deserves representation, which, on the surface, yeah, I agree with that. Not after all this behavior. And another side tangent, race doesn't have a ton to do with this. It does have a significant portion that I will not drop, especially in regards to how she references, conceptualizes, and presents his family and George himself. But aside from that, if she were not a white woman, none of this would happen. Flat out. Prove me wrong. Show me any minority woman of color who has gotten this kind of treatment, who has gotten this much leniency, this much leeway, and even allowed to talk back to people like this. Someone said it in the comments as well that if this was a woman of color, they would have told her to F off capital letters. I 100% agree. They absolutely would have. That's not, that's neither here nor there, but it's always just something I'm remembering of why is everyone bending over backwards for her? I don't understand it whatsoever. Oh, this just reminded me. I brought up the whole 4D chess kind of thing, and then I probably went on another tangent and just dropped that. But this reminded me again of it. Her 4D chess move is distraction, right? She wants you to not pay attention to George, and she wants you to pay attention to her. See her as the victim. She wants you to see that he was the bad guy, she was a good girl, this was an accident, and that you should all just let this go. I'm the real victim. Make me feel like better, yada, yada, yada. I believe that is the first level of her chess move. That's like the initial what she wants to happen. But I think the true 4D level chess of it all is she is being so difficult, ornery, excessive, relentless about everything, deflecting attention away from George, away from the crime, away from anything, and making it about her because she wants, at the end of the day, she knows she's going to lose. She holds out hope that she's not going to, but deep down, she knows she is. She just knows it. And she knows she's playing for the appeal. However, I think the reason she keeps centering herself is because she wants Kranek to sentence her. She does not want Kranek to sentence her crime. Whoops, got a call that interrupted my monologuing. Life happened and now it's the next day. But what a cliffhanger to end on. I just knew I was about to eat with that point. But now I can't remember the specific verbiage of what I was going to say. So I'm going to try to work myself back into it. And then we're just going to see what happens. So Sarah Boone has been centering her case about her, obviously, because she can't not do that. But also, deep down, she is trying to get Kranik to sentence her. She is trying to make sure that he sentences her as a person, not her crime, her heinous, atrocious, brutal, uncaring, unfeeling, merciless, torturous crime. Something I've never heard of before. Something that you hear, like you see in horror movies. Like this is truly, she said it's horrific multiple times, and it absolutely is. And from the moment the police step foot in front of her, she has tried to deflect to any other thing but the crime. She has tried to erase George in every single way. I'll never get over her referring to him as the decedent. And she was using it because it's like, oh, look at this big formal word that I'm using properly, technically, in a motion or a legal letter or what have you. But it was so detached, so uncaring, so unremorseful, so just, yeah, you fill in the blank. So I believe all these antics are to get Kranik's attention so that, he's annoyed with her, but he sees, her, whatever. She's trying to show her heart. And I just want a fair, equal chance. I want to be equal. I want to try my best. I want to succeed. I want all this me, 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 me. That's all he's hearing. All he's hearing is me, 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 me. Judges hear that all the time. But what I've noticed, good judges, not for one moment, have forgotten the crime. Every single second Kranik is sitting in that chair, he is remembering George every time she is speaking. And that will be taken into account during sentencing. Their whole job is to not show how they feel and to be as neutral as possible and then to rule based off of what they see and apply the law equally, yada yada, truth and justice for all. So I don't know if she knows that's the move she's making. I believe she does. And that's her final hope. Obviously, it's not her plan A or plan B or plan C, but that is truly what she wants. She wants him to sentence her at the end of the day, in my belief. Actually, she wants to just get off, honestly. We all know that. But those moments when she's truly being honest with herself, she probably, can make herself forget all the other times, but those moments that she can't run away from herself. And everyone has those moments. No matter how much we live in our own Delulu nation, at certain points, we have to sit with ourselves and say, huh, that's who I am. And she hasn't done that yet. And this trial will force her to do that. And that's why she's stalling the entire time. All right, let's get back to this. All right, and we're back. It's been a few days since that last tangent. This video is taking so long. So let's just wrap this up. More things keep coming out. So I know I said this would be the last thing, but no, there's another one of these that just popped up. And then all the lawyers want money and they're all complaining and the JAC is a mess. So we got to get to that as well. Because I'm not doing this again. I'm not making a second one. So we're going to pile it in this. If this is long, if you leave, sure. If you stay, thank you. Let's keep going. Now, I don't even know what the last thing I said. I know I was at the end of this page. So August 8th, inmate Boone receives laptop at 8:15. Tracy Hall, that's Miss Hall. You remember her from the August 9th hearing when Kranik asked her, hold on, wait, let's get into this first. I spoke with inmate Boone, Sarah, about the items in her property. Inmate Boone stated she has everything she needed to properly represent herself. This entry is for informational purposes only. It actually says inly, but whatever. This is when Kranick asked Sarah point blank period, did you ever tell someone that you had everything you needed?
The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property and the property department so I can anticipate those discovery hard copies.
Is that Tracy Hall?
No, that was Hall. Her last name is Hall.
That's what he just said. See, that's how you know she is just naturally combative of no active listening whatsoever. Was her name Tracy Hall? No. Her last name was Hall. And she was like, actually, there was a miscommunication. And I'm like, of course there is. I knew it was something like this. I knew he would not bring that up unless there was records or something that would prompt him to ask that question. And then, of course, she says it's a miscommunication. And then we find out later it was them offering the second property bag to the hard copies that she couldn't fit after they told her that they couldn't take them. And then she plain lied and got them anyway. Whew. And then she returned the property bag. She said, I don't want it. I have everything I need. And now we have this report, which is part of record. It's part of the record. So if she tries to appeal this, this is also something that they can use. Actually, can you? I think so. Yes, you can, because Kranick brought it on the record. That's why he brought it on the record, because if you take it to appeals, now this gets to come in. And it has been uploaded on the court docket. He made that order so that they would have to upload this log every single week, preserving that for the record. So if she appeals, all of this gets seen. May have said that before already. I'm catching my own self up. So then the solution to all of this turned out to be a third property bag. This all just feels like a joke. Anyway, August 8th at 4:28, inmate Boone turned in a request form attached with the letter for Captain Giovanni. Captain received the letter and gave it to Sergeant DeJesus. Due to Captain Giovanni not being there, she was on vacation, living her best life, and then came back to this mess. It will be given to her upon her return. Inmate Boone was made aware. Informational purposes. The shorthands in these are like making me laugh a little bit. August 9th, inmate Boone received 3 USB laptops at 12:18 p.m. Oh, so she's picking it up a little late. And then she returned it at 4:22 p.m. On August 10th. She picked it up at 8:01 a.m. Then at 9:13, inmate Boone exit for an interview. She had an interview. Okay. Then at 4:09 p.m., she returned it. So where did she take it? Oh, the interview must have been meeting with someone, maybe. I don't know. August 11th, 7:33 a.m., inmate Boone refused breakfast tray. Again, if she doesn't want this uploaded and everyone to know she keeps refusing breakfast, just don't refuse it. Just go. Don't eat it. I don't know. Our tax dollars are paying for it anyway. Might as well take it. 8:17 a.m., inmate Boone received the drives. 4:07, return the laptop. Okay. So that's on that one. So far, she's getting used to it. There are still plenty of hours that she is not using it. So they'll be keeping that tally. And at the end of both of these, I'm going to run the tally and see how many hours that she neglected to use it. On to the next one. All right, so this starts on the 13th. So it looks like they're missing the 12th, but whatever. August 13th, inmate Boone returned to unit from attorney interview with laptop, hard drive, and use. What attorney inmate? Like, who attorney is she meeting with at 10:30 in the morning? It must be one of the YouTube ones that reached out or something like that. But good for her. At least she's doing something. Or maybe that also stands for Billy Lane, because they might not have private investigator notation. So they may call him an attorney as well. I don't know. At 4:04 p.m., inmate Boone returned it. On August 14th, inmate Boone was offered at 8:52 a.m. and she refused due to going to court. Or I'm guessing they offered it at 8, but then it was put in here at 8:52. So she refused going to court. That's fine. I get that. But still, that's 2 hours she could have had it. At 3:46 p.m., inmate Boone was advised not to wear her altered inmate blues uniform to downtown court. Why are you altering it? It didn't help. Anyway, 3:51 p.m., while inmate Boone appeared in her scheduled court appearance, it was discovered by CRSO Jones that Boone had altered her county-issued blues with staples alone, I guess along the seam of her pants legs. Inmate Boone was counseled for this negative behavior and informed that her blues were considered contraband and issued more blues. Yeah, you can't have staples. Where are you getting staples from? Also, what does stapling your pants do? That's so weird to me. Like, if she wanted to alter it up to make it, a little more fashionable, maybe, but staples down the seams, I don't know. She's gonna boon how she gonna boon. At 6:04 p.m., inmate Boone was given 2 property bags to add to her other one, so third property bags for her discovery documents. She was also given several manila envelopes to put said documents in, which means she has to go through and organize them. I doubt that they are pre-organized or overly labeled. Maybe they were nice and maybe they did keep labels on it. Who knows? 8:12 p.m. And this is all on the 14th where we had that long ass hearing. Was that the last one? I think that was the last hearing where it just went on and on and on until she got her way and got her way and got her way and still complained and yelled and complained and yelled. Anyway, she got her times extended to 8 to 10. So she has it 8 a.m. to 4 p.m. and 8 p.m. to 10 p.m. with 8 a.m. to, no, with 8 p.m. to 11 p.m. on some nights. I think 1 or 2 nights.
I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m.
Wow, she got what she wanted. I did not think they were going to give her this because she asked for it from 7:30 to 10. They gave her 8 to 10, but then they gave her 8 to 11 on a few days. So she's getting more time than what she asked for. Wow. Inmate Boone laptop was available and provided to her at 8 p.m. Informational purposes returned at 10 p.m. Good for her. August 15th, issued at 8 a.m. at 9:45 p.m. Oh, so they don't have a return date. Let's just give her the benefit of the doubt and say she used it for the whole 8 hours. So she returned it at 4, and then at 9:48 p.m. or no, that would be 7:48 p.m. Inmate Boone notified staff that she was not sure that she was going to use the laptop because she is unable to get internet. Inmate Boone stated that she will let staff know when she is ready to use the laptop. At 2100 hours, 9 p.m., Inmate Boone approached staff and requested to use the laptop. Laptop was provided to Inmate Boone, informational purposes. So she got it for an hour. Then August 16th, inmate Boone verbally refused her breakfast tray. So it's notated yet again. It is interesting. Well, actually, no. I thought it was interesting that they would log stuff like that with the return logs, but this isn't just for return and issuing of the laptops. This is all of her behaviors that now primarily consist of return and issues, to my understanding. On Friday, August 16th at approximately 7:30 a.m., I informed inmate Boone that the laptop will be made available for her at the hours of 8 a.m. to 4 p.m. At approximately 7:42 a.m., the laptop arrived. Yeah, so now she's trying to get it early, which is, no, it's weird. I was going to be like, good for you for trying to get it early, but no, it's from 8 to 4. Why are you going a half hour early? Because you want to get it? No. On Friday, August 16th, inmate Boone requested an extra small uniform shirt verbally, also inmate request form. Inmate Boone complains that the small uniforms issued to her has an improper fit, too big. Inmate Boone complains the small uniform shirts are revealing. I contacted Uniform Supply. I was informed the smallest uniform shirt is a small. Inmate Boone requested to receive an extra small shirt prior to her meeting on Saturday, August 17th, 2024. Um, yeah, like I said, I'm not going to comment on her appearance, but you can see from her hearings her small uniform, and that's for you to look at, and that's for you to decide, judge, what have you. Just be nice about it, and if you have negative opinions, just keep them to yourself. Silently let them into the ether, because we all know. 11:02 a.m. Devotional BK given at 5:37 p.m. on Friday, August 16th. This was a busy day for her. At approximately 1600 hours, inmate Boone turned in the laptop for Kudapizna. On 8/16, same day, inmate Boone requested a smaller inmate uniform top due to a meeting scheduled for her case. Who's she trying to impress? I asked inmate Boone what size top did she currently have on, and she informed me a small. I informed inmate Boone that size small was the smallest inmate uniform top that FDC had to offer. Inmate Boone requested that I look for a different small that may fit smaller than the small that she is wearing. Of course she did. I informed inmate Boone that I would not look for her and smaller small. She was informed to wear the t-shirt or a thermal under her top if she felt it was too big and might show too much. Yeah. So she asked that at 7 p.m. and 10 a.m. Again, this is another example of what we've been talking about. She asks the same questions again and again and again. And she thinks she's slick because she's asking two different people. She asked this Frank person at 10 a.m. and then Yolanda at 7 p.m. So it's one of those mom rejected, go ask dad kind of things, where she will ask the question again until someone provides her the answer she wants, because she doesn't believe anyone's ever telling the truth. And if you don't give her what you want, you're lying, you're slighting her, all of these other things. Stop asking for a small, just tuck it in or something. There are ways besides having a staple that you can alter uniforms without it breaking regulations. Just tuck that shit in. August 16th, Discovery Drive, approximately 1908 hours. 1908. So that's 7, right? So she got an hour earlier. Okay, 8/16. Laptop returned at approximately 21 hours, 45 minutes. That's 9:45, I think. I informed inmate Boone that she has until 2300 hours to utilize it. Yes, because she has until 11 p.m. on some nights. She said she need a mental break and would not like to utilize it. This entry is for informational purposes only. There you go. You needed a mental break. So don't be complaining that you don't have enough time, because you need to be using every single second. If she's playing smart, she doesn't have to use it the entire time. Just keep it with you. Just have the laptop with you the entire time, whether you want to use it or you don't. But when you turn it back in and request it later, it's only going to look worse for you in the end, because you're going to go back and say, I didn't have any time to look at it. And they're going to be like, actually, you did. Again, it may not be what you wanted. A lot of things aren't what you wanted. You're in jail for second-degree murder. None of this process is supposed to be comfortable for you. None of this process is supposed to be preferable for you, or it doesn't have to be preferable to you. You have your rights, you can make some decisions, you're provided so many opportunities on a litany of different issues. They're never good enough for you, and you're not even utilizing them to the full extent once you get them. And also, for everyone who keeps talking about the appeals, you have this for appeals, just to let you know, there's only about 5 to 10% of successful appeals. 5 to 10%, because appellate courts don't want to overturn rulings if they don't have to, because that makes everything so messy and it sets different precedents for all of these different things. So you have to have actual good, strong arguments that require an appeal, not just, okay, yeah, things could have been better if. It has to require it. 5 to 10%. So Keep that in mind every time you keep thinking, oh, she has all of these arguments. Oh, appeal, appeal, appeal. 5 to 10%. I don't think Miss Boone has been in the 5 to 10% of anything in a positive way, anyway. So we'll see if this one is her big break, just like her mental break, just like my mental break. How long is this video? Oh my gosh. August 17th, 7:20 a.m. Inmate Boone requested to shower prior to 800 due to a meeting conducted. Inmate Boone was afforded opportunity to shower at approximately 7:18. Good for her. At approximately 7:15, I informed inmate Boone the laptop USB drive would be available to her usage. 8 to 4. Again, she's asking for it earlier, this time at 7:15. Girl, just wait till 8. You don't even use it the whole time anyway. The USB drive and Discovery hard drive arrived approximately 7:25. Same day at 8:02, the 3 hard drives and laptop were issued. Same day on 3:22 p.m. What is this? Oh, negative officer contact. Remember how she said in the past, I've never argued, I've never missed a court date. I know that's different and whatnot, but I just know she's always be arguing. So 3:02 p.m. on August 17th, 2024, inmate Boone was on an interview with a professional visitor. The visitor informed staff that he had legal mail for inmate Boone. Sergeant Dunn, Corporal Hall, and I searched inmate Boone property. During the search, the following items were amongst her legal mail: paper clips, staples, clear Ziploc bags, one written tablet with staples attached. During the search, inmate Boone became argumentative and questioning the staff why her property was being searched. I explained to inmate Boone that she is subject to search at any time. Inmate was not receptive. I bet. I bet she wasn't. But yeah, you know this. That's how we found out about the sliced cheese. You got raided when you want you got raided when you didn't expect it. They found your cheese stash and then it got written down in here. Now you have your paper clips, staples, yada yada yada, which they told you at the last hearing on the 14th that you can't have those things. That's why Kranick said that Miss Cashman Esquire had them all removed. Still don't know how she did all that, if she did all that herself or had someone else do that. But yikes. Yeah, she knows she's not allowed to have it. And that's why the jail has to search all mail that goes between in and out because of things like this. Because you can turn that into a weapon. Absolutely. Sharp metal or metal that can be sharpened. Because, yep, if you want all these papers, you want all these hard copies, you get them as free form paper. Mess everywhere. Have fun. I love how she just keeps asking for more and more hard copies that she can't store nor organize. It's because she just wants to force people to do actions and to give her things, but then doesn't know what to do with it afterwards. Anyway, 8:44 p.m. Drives laptop issued. 22 hours returned. 8:18, 6 a.m., 6:03 a.m. Inmate verbally refused breakfast. There it is again. 7:43 a.m. On Sunday, August 18th, 2024, at approximately 7:15 hours, I informed inmate Boone one laptop USB Discovery hard drive would be available for her usage between 800 and 1600 hours. Approximately 7:24 hours, one laptop USB and Discovery hard drive arrived in B dorm. So yet again, she has to be told, wait until 8 a.m. Why do you not get this? Why do you keep thinking this is going to change? She might have gotten it early one time, and now she's going to keep going again and again and again, hoping she can still get that special treatment. On Sunday, August 18th, at approximately 8 a.m., I issued one laptop. At approximately 8:10, I was informed by inmate Boone the issued laptop was not charged. Sergeant Dunn was notified and responded with a charger. At 9 p.m., the laptop began charging. Inmate Boone was notified. At 10:15, I issued one laptop. Inmate Boone, 3 USB, Discovery hard drive secured in one plastic bag together. At approximately 10:45 a.m., inmate Boone Sarah turned in a request. The request referenced receiving an ink pen and paper from staff. There you go. Reasonable request. Give her all the pens and paper she wants. Sergeant Dunn was notified and retrieved inmate Boone request form. Sergeant Dunn returned to B dorm with 2 inmate pens So there's 2 inmate pins. I wonder if those are like special pins, probably no kind of metal or whatever. 2 inmate pins for inmate Boone, Sarah to utilize. At approximately 10:59 hours, I issue 2 inmate pins to inmate Boone, Sarah. Sergeant Dunn informed that she issued inmate Boone legal paper yesterday. Okay, so she has paper. At approximately 11:04, I was informed by inmate Boone, Sarah, the laptop was charged at 52%. Yeah, they should probably just be charging it. Like, that's not that hard. Whenever they receive the laptop before they give it out to her, they should just charge it, make sure it's charged, or at least just plug it in to make sure that she has something to work with. On August 18th at 8:19 p.m., there's so much for this one day. Girl, calm down. No, this isn't all her fault. I understand. As the dorm officer, I am aware that inmate Boone, Sarah Boone, I don't even know what I'm reading anymore. 8:19 p.m. As the dorm officer, I am aware that inmate Boone Sarah is to receive a laptop per a set schedule. I am also aware that she tends to use it frequently. However, I noticed today that she didn't ask for it since my arrival to shift. I then asked if she would like to utilize her laptop privileges, to which she stated, "Yes, I've been wanting to use it, but you didn't ask me. I was told that you guys are to ask me if I want to use it, and I'm not to ask any questions." She was probably told that once after nagging someone and is just going to run with it. But okay. It should be noted that inmate Boone has been briefed by staff regarding her laptop usage since she first received it, and is to also ask the dorm officer for it if she would like to use it. Again, she did not notify me that she would like to use it at any time since my arrival to shift. She received the laptop, and Corporal Ward was notified. Moments later, while I was conducting a visual inspection, she stated to me that the laptop was low on battery, to which I looked and confirmed that it was. Inmate Boone then requested for statement form stating, "This is the 3rd day in a row that it's been given to me with a dead battery. It's supposed to be charged. May I have a statement form that they give you guys to document when I don't use the laptop? I want to write about the laptop constantly being dead." She was given the form and the laptop was placed on the charger. This entry is for documentation purposes only. Yeah, charge the laptop. Is this the next day? Oh, it's the next day. Great. Well, kind of. On August 19th at 1:43 a.m., so that night, inmate Boone Sarah is currently pro se and is allowed a laptop per scheduled hours. For the day, inmate Boone Sarah currently pro se and is allowed laptop per scheduled hours. Okay, whoever is typing this, the laptop had a low battery and needed to be charged. An entry was made hours ago by this officer regarding the battery, and also inmate Boone requesting a statement form. While collecting the form from inmate Boone, I informed to her that the laptop is now charged and should be ready for use in the morning. I also told her that I will make the day shift officer aware that the laptop is to be charged once she is finished with it so that she can utilize it during the night shift. Inmate Boone then stated, "Miss Ford, I will take the form back. I didn't really want to." Miss Ford, I will take the form back. I didn't really want to turn it in. It's okay. I will keep it in my documents. Just please let the officers know that it has to be charged. I can't do anything without it. I gave her the form back, and Sergeant Moreno was notified. This entry is for documentation purposes only. See, this is what she does. She threatens people with going above them. If you don't do this for me, I'm going to tell the judge. If you don't do this for me, I'm going to call the cops. If you don't do this for me, I'm going to submit a statement form. And then takes it back because she didn't actually want to do that. She just wanted people to do things for her. She wanted them to do what she wanted them to do. She didn't actually care so much about the actual grievance of this is unacceptable. It hasn't been charged for 3 days. I just want to scare you so that you will follow my orders from now on. 6:02 a.m., inmate refused breakfast. Okay, my God. Those are the behavior forms. So let me do some math. Let me do some Hollywood movie magic. She has not used this laptop for 41 hours and 27 minutes. out of the 114 hours she had it available to her. 40 hours really adds up. So I understand not using it 24/7, but you complained for it. You put yourself in this situation. You should be using it, or at least be pretending to use it the entire time. That way, you have something on appeal. If you used every single moment of your time and you were still completely unprepared and that no one was listening to you and that you didn't get anything that you asked for, then you might have stronger arguments. Still not enough, in my opinion, but stronger arguments. Moving on to these endless documents from other attorneys requesting their coin. And they deserve it for dealing with this. All right, let's see. Winston Hobson. Okay, he submitted this first. Oh, there's a lot here. Okay. Okay, there's a lot here. I'm confused. What's the date? Let's go after the date. Certificate of service. 16th August. August 16th is when Hobson submitted this. Comes now Winston E. Hobson, ex-squire, that's right, as the private court-appointed attorney in the above-titled cause, and files this motion for attorney's fees pursuant to section da-da-da-da, and in support of states as follows. First, the undersigned Winston Hobson was duly appointed to represent the defendant September 8th, 2023. Two, the undersigned is now billing in this cause because the case has reached final disposition in this representation. The Judicial Administrative Commission's response to the billing was to object to the flat fee amount of $15,000. See, they were only getting paid $15,000 and she wanted $15,000 for her neuropsychologist expert witness. No. The JAC be playing these people. $15,000 for this mess? For attorney's fees and a hearing is requested. A copy of the objection letter is attached. Copy of the order on June 20th. Okay, so all of those stuff is just copies. So it's not really 23 pages. 3, the undersigned counsel represented the defendant from the date of the appointment through February 9th, 2024, when the court discharged counsel and appointed attorney Patricia Cashman. Defendant now represents herself after discharge of attorney Cashman. I love that you added that. Probably makes him feel better about leaving himself. All of these people must feel validated for their decision to withdraw. The order of appointment of undersigned counsel is on file with the JAC. The defendant was ordered to represent herself. Got to put that in there twice. 4, the defendant was charged in the above style cause with 1 count of second-degree murder. The maximum sentence the defendant faces is life imprisonment. I know that's right. 5, because of the length of representation in this case, the volume of discovery, the witness list, and the complexity of issues, counsel is seeking payment of the flat fee in the matter. This case involved voluminous pages of discovery, filling 2 or more bankers' boxes, photographs, numerous hours of audio and video statements in the case, viewing voluminous amounts of video material in the public domain, hours of consultation and discussions with an expert psychologist in attempts to develop defenses. Yeah, in attempts to develop defenses in the matter. Letters to and from the defendant, video and in-person visits with the defendant in the Orange County Jail, numerous consultations with the investigator, in-person visit at the jail with the investigator, Mr. Billy Lane. Oh, so he met with Mr. Billy Lane. See, this is the thing. Sarah keeps saying no one's doing anything in her case, but she has no idea. I mean, she's learning an idea of how much actually goes into all of this. Counsel reviewed numerous and very extensive letters from the defendant and did extensive review and research into legal matters, many at the defendant's request. Oh, yeah, looking into all the bullshit she wanted him to say, but he didn't want to. So he's like, fine, I'll look up this crazy stuff. Because you know she said it as though it were fact that she knew these defenses were possible. Probably a jailhouse lawyer, who knows. So he took the time to go do that. Counsel spent no fewer than 200 hours on this representation. Wow. Counsel copied and sent over $400 copy costs of information to the defendant. Until a court order is entered, JAC will not refund this amount. He put up $400 of his own money to get her information that she's not going to give him credit for giving her anyway. Because according to her, they did nothing. They didn't answer any questions. They didn't help her. 200 hours of work. See, she put in all of those hours within her letters to the judge, being like, I've been represented for 9,000 hours and he's only met with me for 5. Yeah, because they have shit to do. And now you're seeing what they were doing and all the hoops they have to go through regularly as lawyers. And you still have no appreciation for it. She will never admit that she understands what they were going through now, as in that they were doing a lot more work than she gives them credit for. She'll never go back and give them credit for that. It's just who she is. 6, undersigned counsel has submitted a voucher to JAC for payment. 7, Florida statute state a private attorney appointed by the court from the registry to represent a client is entitled to payment as provided per da da da. More other Florida statutes. I don't really want to read this. It's basically just saying, give me my money. 9, undersigned counsel has attached and made a part herein the objection letter and order of the court. 10, as a result of undersigned counsel's acceptance and work on the above styled case and the incredible demands of the case on the defendant, more like the incredible demands of the defendant about the case, the extreme consumption of time and effort daily for the duration of the representation. Counsel often had to set aside various work demands and other activities. Lost opportunities resulted. Exactly. Does she care? No. They didn't do anything for her in her mind. 11, prior and after undersigned counsel being appointed, other attorneys were and since appointed to represent the defendant. Those attorneys also did very significant work in the case as evidenced by their motions for attorney's fees with various attachments. They too were rejected by JAC to receive the flat fee amount in this cause. JAC, stop. Give them the money they deserve. 12, because of what is outlined above, the work done by the attorneys failing to pay each the flat fee would be confiscatory. Confiscatory. Would be confiscatory. Wherefore, it is respectfully requested that the court enter an order approving the amount of $15,000 bold for attorney's fees, directing that the undersigned be compensated by the state of Florida Justice Administrative Commission and for such other and further relief as the court deems just and equitable. Winston E. Hobson. Let's see. What did the JAC say? Oh, dear counselor. You can't even use his last name? Okay. Dear counselor, pursuant to Florida JAC, reviewed your intended billing affidavit and documentation in the above manner for compliance with statutory and the JAC contractual requirements. JAC objects to your billing for attorney's fees in the amount of $15,000 for the following reasons. Your date of appointment on this case, 9/8/2023, the legislator established flat fees of $15,000 for representation of felony non-capital murder cases. Multiple attorney case. The aggregate amounts billed for attorney's fees amongst all attorneys appointed to represent this case exceed the flat fee established in the General Appropriations Act. The flat fees prescribed under and the General Appropriations Act comprise the full and complete compensation for private and court-appointed counsel. Paragraph contract provides for any case subject to a flat fee if attorney withdraws or is discharged prior to completion of the case, attorney shall only be entitled to a portion of the flat fee to be determined by the court. Wait, they want all of the lawyers that have worked on this case to split $15,000. Absolutely not. My God. 4 years of work over 8 different attorneys. Yes, technically 4, but 8 were appointed. People don't like that you say 8 attorneys because she lost 4 not on her own. They still were appointed. Factually, it's in her record. She was appointed 8 lawyers. She drove off 4 and have 4 of their conflicts because the world hates her. But damn, they want all of them, those 4, to split $15,000. Crazy work to me. Or maybe it's just 3 of them because one of them was private, paid for not by the JAC. Where the court appoints more than one private attorney, the total compensation for the initial and all subsequent attorneys may not exceed the flat fee. Absent proceedings under da 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 da. You were appointed to this case but did not represent the client through the entire course of the case. Thus, the court appointed more than one private attorney to represent this client. Pursuant to da da da, the court must apportion the flat fee among all the private court appointed counsel who worked on this case. In this manner, you were the third of 4 attorneys appointed to represent the defendant. Wow. So Kranek is going to have to divvy up this 15,000 amongst those 3 or those 4. Because the court must apportion the flat fee among all private court appointed counsel, the matter must be heard before the court in a single hearing. All of them in one hearing against the JAC. I want to see this battle royale. You will need to coordinate the hearing date and time with JAC and all attorneys listed below. In this case, the following private court attorneys represented the client during the following periods. Mark Consolo, date of appointment 6/22/22 to 7/11/22. So he put in less than a month. Case open, no billing to this date. Okay, so Mark Consolo isn't even asking for money. Okay, because he realizes I did a month worth of work. Frank J. Bankowitz, date of appointment 7/11/22 to 9/8/2023. So he put in work. He put in the most, he got abused the most. Billed $15,000. He deserves that. He deserves $15,000 for what she did to him and dragging his name and all that stuff. Winston E. Hobson, dates of appointment 9/8/23 to 2/9/24. Billed at $15,000. Patricia Cashman, dates of appointment 2/9/24 to 6/28/24. Open case, no billing to this date. This says to this date, but we know she submitted something that we're about to get to next. Oh my God, are we done with this? Do I have to do the rest of this? Okay. The trial court will decide the amount of compensation which each attorney is entitled. As to your representation, the decision is based on work performed from September 8th through your discharge of February 9th. If the attorneys are agreeable to the division of the flat fee, the attorneys may execute an attorney settlement agreement for splitting the flat fee located at. So if y'all all agree to split the cash, we don't even have to do this. But I wouldn't. I do not think they are going to give out 3 sets of $15,000 payments, but maybe, I don't know. Maybe if you could do 30,000 divided by 3 so they each get 10,000, I mean, that seems more fair to me, I guess. Compensation in excess of the flat fee. When the attorneys seek total compensation in excess of the flat fee, the attorneys must follow the procedures and requirements established in pursuant to the motion for attorneys' fees must be filed with the chief judge. The chief judge or designee must hold an evidentiary hearing on the issue of whether to exceed the flat fee. The order to pay will require written findings that the fees claimed are reasonable. The order to pay must identify the unusual and extraordinary nature of the time and efforts associated with the representation, which warrant exceeding the flat fee pursuant to and makes blah, blah, blah. Yeah, there are definitely unusual and extraordinary circumstances and nature here, but let's see if that'll be enough for Kranek to rule in their favor. For Kranek to rule in their favor. The attorney shall have the burden to prove the entitlement to attorney's fees, costs, or related expenses. Your motion to the court to approve compensation must state whether JAC objects to any portion of the billing or the sufficiency of the documentation. A copy of this letter of objection must be attached to your motion for attorney's fees. JAC requests a hearing on your motion and requests to appear through communications equipment such as video conferencing. The JAC registry contract required that you serve a copy of your motion upon JAC and provide 20 days notice of any hearing on your motion. If you have any questions, please email JAC legal section. Please be advised that this letter is valid for up to 1 year from the day. Okay. And then this this is the court order stripping Miss Boone of her right to counsel. Court-appointed counsel, not counsel in general. She can still have counsel as she has been meeting with those YouTube lawyers. That just proves to you right there. She is allowed to have counsel. She just can't afford it. And at this point, I don't care. Next. Now, this is Miss Cashman's motion for attorney's fees. Oh my gosh, why is this so long? Why is this so long? Y'all, do I have to do this? Are y'all gonna be mad if I don't do this? Okay. You don't have to yell. Okay, fine. Comes now Patricia A. Cashman, Esquire, work as the private court-appointed attorney in the above entitled case and files this motion for attorney's fees pursuant to and in support of states as follows. 1. The undersigned Patricia Cashman was duly appointed as the counsel for the defendant February 9th, 2024. Counsel was the 8th attorney appointed and the 4th private court appointed attorney. 2. The undersigned is now billing on the cause because the case has reached a billable point. The Justice Administrative Commission's response to the billing was to object to the flat fee amount of $15,000. Run her money for attorney's fees and the $1,800 for reimbursable costs expended by this attorney, and a hearing is requested. A copy of the objection letter is attached and marked as Exhibit 1. And she spent $1,800. So Hobson spent $400 of his own money doing shit for her. She spent $1,800 of her own money doing shit for her. And Sarah does not care one little bit. 3. The undersigned counsel represented the defendant over a 4-month period. I know it felt like 4 years. Counsel spent well over 100 hours on this case, on said case, as evidenced by the attached certificate of time marked Exhibit 2. Over 20 of those hours were spent with the defendant. Whew. So again, Sarah's like, she didn't do anything for me with me because she has no idea what goes on in actually defending a case. So remember when I said she had 114 hours that she could have had the computer and she didn't use 40 of those hours? Miss Cashman spent over 100 hours on this just to get where she got. So it's going to take Miss Boone at least 2, 3, 4 times as long to get caught up. And she doesn't have that time. She does not have that time. So good luck. 4. Miss Boone was charged by information with second-degree murder. There was a vast amount of media attention to this case. Miss Boone was accused of putting her boyfriend in a suitcase where he died. There was a video of the incident that went viral. Counsel made preparing this case a priority as the case had been pending since February of 2020. The final disposition of the case was the court entering an order that Miss Boone had waived her right to counsel. So, okay, I thought she was just being shady, but she does need to put it in there so that she can show this was high profile. I prioritized this. I went above and beyond what I would normally do for my other cases in order to help this case that had been stalled since 2020. There was a significant amount of discovery to review, multiple CDs, DVDs, paper discovery of over 400 pages of reports and statements, 2 banker's boxes of files obtained from previous counsels, and background information on the relationship between the deceased and the defendant. I know that background information was probably messy. She's probably talking about the police reports. The state listed 23 witnesses, 2 of whom were deposed by counsel and 7 of whom were deposed by previous counsel. So, of the 23 witnesses, she has 9 of those depositions, which I guess is better than nothing, but that just means there's a lot that she cannot anticipate, nor does she have anything to fight back against them with. Because with the depositions, you're allowed to see their testimony, what they're supposed to testify to. And if they don't say the exact same things that they said in their deposition, you get to impeach them by reading their statements and saying, so you're lying right now. Or you were lying during this deposition when you were also under oath. So, how can we trust you? But now there are a lot of witnesses that she can't do that on. But she does. The last 2 that she got were the 2 investigators, Scott and Chelsea, which I wonder why they waited that long to depose those 2. They should have been like first on the list, honestly. But she got them, and I don't know what she's going to do with them, but I'm sure she's going to take her time cross-examining them. There were 8 separate statements given by the defendant. Counsel also needed to review the media accounts that potential jurors may have seen. The case was heavily covered by Court TV, News Nation, Fox, local news channels, and the Orlando Sentinel. Know your lawyer. Legal bites. Oh, lawyer, you know. Oh, Miss Cashman, that's funny. Know your lawyer. Lawyer, you know. Should I change my name to this? This new channel name is Know Your Lawyer. Just to counter Lawyer, you know. No, just kidding. I love Lawyer, you know. I think he is probably the most unbiased law tuber on YouTube. Emily D. Baker is my personal favorite. She just gives me everything that I need. But Lawyer, you know, is very lawful good. Emily D. Baker is like chaotic good. And then Natalie Lawyer Chick is like neutral good. And then apparently Nick Rekieta is lawful evil. Yikes. Which I kind of want to look more into, but I don't know him like that. So, Legal Bites and Bruce Rivers. Legal Bites is great. She's really solid. She had some good, solid coverage of the Amber Heard trial. And I know she actually started that huge, big legal law tuber boom because she was covering the Depp v. Heard trial live. And then all the other YouTubers like were coming in and being guests for her, or like other talky people, and then they went and did their own streams, and then it kind of just exploded. Emily D. Baker was already doing it as well, but I noticed that it really started to pick up after Legal Bites coverage started to get popular. And Bruce Rivers is just great. He doesn't seem like he takes himself too seriously, and the father-son dynamic he has on his channel is also very touching. Speaking of, I just recently found out that my dad found my channel. Hi, Dad. Um, this little Easter egg is for you. Don't tell Mom. Did multiple stories on other channels. Many of the previously held court proceedings were televised, and the letters written by the defendant were published and analyzed. The defendant wrote a 58-page letter to the court and had previously written multiple long letters to the court that counsel needed to review to determine the potential impact on the case and develop a strategy for jury selection. Counsel spent over 20 hours at jail conferences with the client. Glad she brought in that 58-page letter to show how ridiculous it all was. And that, yes, all of her lawyers read every single letter she sent them and sent the court because they needed to know how that was going to impact things. That's why they didn't show her everything. That's probably why they didn't give her some of the discovery, because they're like, you know, you're going to put these in the letters, and then we're going to have to try to work around that, because they have to try to account for all the destruction you are going to do to your own defense and still try to provide you zealous advocacy. 5. Undersigned counsel has submitted a voucher to JAC for payment. 6. Florida statute. Hobson did these same things. 6. Florida statutes. A private attorney appointed by the court from the registry to represent a client is entitled to payment as provided in section da-da-da. 7. Florida statute. The Justice Administrative Commission shall review an intended billing by private court-appointed counsel for attorney's fees based on a flat fee per case for completeness, and compliance with contractual and statutory requirements. The Commission may approve the intended bill for a flat fee per case for payment without approval by the court if the intended billing is correct. An intended billing that seeks compensation for any amount exceeding the flat fee established for a particular type of representation as prescribed in the General Appropriations Act shall comply with subsections 11 and 12. The legislator recognizes that on rare occasions an attorney may receive a case that requires extraordinary and unusual effort. A. If counsel seeks compensation that exceeds the limits prescribed by law, he or she must file a motion with the chief judge for an order approving payment of attorney's fees in excess of these limits. D. If the chief judge or designee finds that counsel has proved by competent and substantial evidence that the case required extraordinary and unusual efforts, the chief judge or designee shall order the compensation to be paid to the attorney at a percentage above the flat fee rate. Depending on the extent of the unusual and extraordinary effort required, the percentage shall be only the rate necessary to ensure that the fees paid are not confiscatory under common law. The percentage may not exceed 200% of the established fee rate. So 30,000 would be the cap because that is 200% of 15,000. Absent a specific finding that 200% of the flat fee in the case would be confiscatory, if the chief judge or designee determines that 200% of the flat fee would be confiscatory, he or she shall order the amount of compensation using an hourly rate not to exceed $75 per hour for a non-capital case and $100 per hour for a capital case. This is, I don't know. There are lawyers out there that easily charge $400 to $500 an hour. $175 to $100 an hour for this case, bananas. The JAC runs a tight leash over there. I'll say that. However, the compensation calculated by using the hourly rate shall be only that amount necessary to ensure that the total fees paid are not confiscatory. 8. As a result of undersigned counsel's acceptance and work on the above style case, counsel was unavailable to meet with several potential new clients who then hired other counsel. Opportunities to take on new clients had to be declined, resulting in a loss of fees. See? I bet she would have wanted any of those other clients. 9. Because of what is outlined above and the work done by the attorney, failing to pay the fee as requested would be confiscatory. Wherefore, it is respectfully requested that the court enter an order approving the amount of $15,000 for attorney's fees and $1,800 for reimbursed costs for a total of $16,800, directing that the undersigned be compensated by the State of Florida Justice Administrative Commission and for such other and further relief as the court deems just and equitable. 21st day of August. So a few days after Hobson. You notice how these read similarly because they probably have a template that they follow because they know exactly what the JAC requires. Unlike Miss Boone, who just free writes to the world, give me money. This is their objection letter. And just like the other one was similar, I think this is the same copy and paste, just with her money that she's asking for. So instead of $15,400, it's $15,000 and $1,800. But then they put all of this, 15,000, 15,000, 15,000. Okay, because the last one she had not billed yet. Now she is billing 15,000. All of them are billing 15,000. And defendant pro se, dates of appointment, 6/28 ongoing. Defendant is not entitled to another court-appointed attorney, period. And the JAC is the one who pays for that. So the JAC is basically saying, in summation, from start to finish in the investigation of the murder of Jorge Torrez, the representation of Sarah Boone shall not exceed $15,000. And normally, that's not too bad when you have just one lawyer. Not great, not too bad. But when you have 8 /4 who are actually buying for that 15,000, then this looks unreasonable. And I think they should extend it at least more so that there's more for them to split. If you don't give them all $15,000, I would give them all 10,000 at least. I think they did enough for that. And what is this? Oh, this is just her time breakdown of her billing. Client attorneys. I don't want to read this. I'm just going to glance through it. Reviewing discovery, email correspondences with previous investigators. So everyone has been working with Mr. Billy Lane, it seems. Reviewed witness list, continue discovery reading, because, oh, the discovery is 413 pages, and the dockets are 262 pages. So she has all of that to go through and try to organize. Previous investigators' report of 18 pages. So the investigator has already written his own reports. Review depositions. Okay, so these people have been deposed. Moses Torrez, I'm guessing that's George's brother. Brian Boone, 34 pages. Oh, so the brother had 54 pages of deposition and Brian Boone only had 34 pages. Jay Martinez, 24 pages. Maricel Torres, 20 pages. I'm so sorry for mispronouncing names. K. Rodriguez, 17 pages. B. Torres, 16 pages. And S. Robinson, 10 pages. So it looked like one of his brothers has the most to say out of all of them. And then Brian with the second most. Review media on the internet. Jurors will have been exposed to. Legal bites. Not legal bites, just 12 minutes and 26 seconds. WESH, 2 minutes. Court TV, 30 minutes. Parkland Judge weighs in 12 minutes. So she gave Parkland Judge the same amount of time as legal bites. You deserve more legal bites. Go look at her channel after this. Review digital file from investigator. Draft letter, draft sign, draft all these things, jail conference with client for 2.5 hours. See, all of these things, she's saying she didn't meet with anyone at any time, but because she keeps moving the goalpost of she didn't call me, they didn't answer my phone calls, they didn't meet me in person, they didn't answer my letters. And she says that at different various times. So it seems like they're not meeting with her at all, but they are in different forms of communication. But at the time she's highlighting another one, she's diverting from other forms of communication. Let's see. Oh, these are reviewing more depositions from I don't know any of these people. Juan Torres. I know that is one of his brothers. 58 pages. So that's even more than the other brother. And I think Juan Torres was the one who did the interview with the police, which I will be getting to. That's the next video. But this one just takes forever. Listen to 911 call, watch suitcase video. Whoa, she said watch suitcase videos, 11 minutes and 1 minute. She's saying there's an 11-minute video? We know there's like a 1 to 2 minute video. And I know she made 2 videos, but my knowledge is that one of the videos was like 2 minutes and the other video was like 20 seconds. Is she saying one of those videos is 11 minutes or that she just spent 11 minutes watching it? Because wow, if there's an 11-minute video out there, that like destroys me a little bit. Yeah, I'm just looking to see if there's anything more interesting. Legal research on battered woman syndrome, legal research on PTSD. So these are some potential defenses she was going to go for. Correspondence with expert, draft letter to jail. You see all these draft letters, all of these things take time. And so some people I've seen think the JAC is being a little harsh with her or people are expecting too much. They have to. That's how law works. All of these things go into it. And when you go pro se, you are treated like a lawyer. Voicemail, review media on internet, jurors will have been exposed to. Court TV, 26 minutes, 6 minutes. KYL, Know your lawyer. Lawyer, you know. 1 hour and 40 minutes. Wow. She spent the most time watching Lawyer, you know. Personally, I get it. So, Lawyer, you know, should be feel accomplished. I don't know if accomplished is the right thing, but good for you getting your shout out. But now this channel is secretly known as Know Your Lawyer, the Shadow Lawyer You Know channel. Oh, status management on case, 0.7 of an hour. Review 58-page letter to client, wrote to judge, 2 hours. Additional research on motion to withdraw. She said after that 58-page letter, no, I'm done. Goodbye. Review letter client wrote to judge, 4 pages. That was the other one where she bashed her. And then a conference call. She had a conference call after reading those letters. That's funny. Hearing for motion to withdraw. Draft clarification order. Da, 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 da. Total hours 118 hours. Wow. Yeah. Pay Miss Cashman her money. Are we done yet? What is this now? What is this? The Justice Administrative Commission has requested that undersigned counsel present this email to the court. Okay, is this her rejection email? The Justice Administrative Commission has received and reviewed the motion for attorney's fees as the above referenced matter. JAC will not be filing a formal response and takes no position as to your motion except JAC objects insofar as the estimated attorney fees exceeds the statutory presumption of non-indigence pursuant. JAC does not request to participate in any hearing set in the motion. You may utilize this email in lieu of a formal response and should attach it to your motion when you provide it to the court. If the defendant is convicted, the defense must file an accounting with the trial court within 90 days of disposition. Failure to file this accounting will delay JAC from processing any pending due process services bills for payment. Please note, all email is potentially available as a public record. This email or any attachments provided may contain confidential information intended for the use of the designated recipients named above. If you are not the intended recipient and have received this email in error, please notify the sender immediately by returning the email and deleting the message. And be aware that any message dissemination and distribution or copying of this communication is strictly prohibited. Oops. Oopsies, I guess. Maybe I shouldn't be showing people's info like that. Okay, anything else? Of course there is. Of course there is. What is this? Oh, this is just her transcriptions invoice. Okay, yeah, because the court said send me any invoices for how much it costs to get Miss Boone the transcriptions. And so it looks like it costs court reporter appearance fee for $125. Yeah, because someone has to type up the depositions. Other transcripts, total pay due, mental health. The following invoice is submitted and attorney is waiting reimbursements, $1,800. Look, if she is saying she needs $1,800 due to her mental health, grant her that money. I get it. I would ask for $1,800 of mental stress just because of this too. I know that's not what she's actually asking, but in my head canon, it is. What else? Oh, Bankowitz. LOL, that's all you did? Okay, we can do this. Comes now Frank J. Bankowitz as court-appointed counsel in the above entitled cause pursuant to section and files this motion on attorney's fees and in support thereof states as follows. 1, that the undersigned attorney was court appointed to represent the above defendant, Sarah Boone, on or about July 11th, 2022, wherein the defendant has been charged with second-degree murder. Undersigned counsel was attorney number 7 in this case. No, you weren't. What? You were attorney number 6. Oh, Banksy. Good old Bankowitz. That's funny. Yes, you were attorney number 6. Hobson was 7 and Miss Cashman was 8. 2, that the undersigned attorney worked on this case for over a year and has spent approximately 175 hours, including 45 hours with the defendant. Oof. You deserve a promotion for that. I don't know what promotion you can get, but you deserve it. Those are 175 hours of his life that probably shortened his lifespan by a few years. So he deserves his money too. 3, that on or about June 28th, 2024, this court entered its order finding that the defendant had forfeited her right to counsel after having 8 different attorneys appointed to her case, and then each attorney ultimately withdrew from this case. Okay, we do know that's, well, actually no, that is right. All of these attorneys did withdraw from the case. Even though some of them were granted because there were conflicts, they did all have to withdraw. So, correct. 4, part of this order read that the defendant was not entitled to endless lines of court-appointed attorneys until she found the one she preferred, and she learned that the very hard way. 5, counsel is seeking the contract fee of $15,000 for his effort on behalf of the above defendant. Wherefore, it is respectfully requested that his honorable court enter an order approving in the amount of $15,000 for attorney fees and directing that the undersigned be compensated by the Florida Justice Administrative Commission for other such relief as the court deems equitable and just. Hereby, certified electronic mail. Da, da, da. Okay, so he was probably the last one CCing everyone else. But I mean, come on, 5 points. So if I were to rank all of them, Miss Cashman gets my 1. She gets the gold because she put in a lot of work and she provided the most evidence. Then Mr. Hobson Esquire gets my 2, second place, silver, because, he detailed it out and he attached the order, which I always love that. Just a little shade thrown in the face to show this is why this was extraordinary and unusual. And then Bankowitz gets the default bronze because what even is this? You submitted this because you're like, well, I think I need to throw my hat in the ring. Okay, and with all of that, I think that is all of the most recent documents. Let me go check one more time because I don't want to hear anyone complaining. I don't want to hear anyone complaining that I should have looked at something else. All right, that looks like everything. Yeah, and we just did that. That looks like everything. Whew. So this video has taken forever. If you've made it this far, thank you for sticking it through. And yeah, the next video in this series is going to be looking at the interviews from the neighbors, the property manager, George's brother, and I think Brian had a second interview as well after Sarah's infamous interrogation. So I think I'm gonna put that in there as well. And then after that interviews video, we will be finally doing the interrogation video. I imagine that video is going to take forever. It's going to be long. I'm not going to apologize for how long, how much I talk in it. I'm not going to apologize anymore for talking. So it will be what it is going to be. So yeah, Sarah wants her a neuropsychologist to try to provide an excuse for her killing her boyfriend. I do not think she is going to get that. The JAC is saying no. Poor Kranick, he has a lot on his plate, I'm sure with all of his other court cases, but now he has to set a hearing to deal with this so that he can say no now that the JAC has said no. And then he has to have a meeting with all 3 Esquires, a 3-way deadlock against Kranick, Hobson, Bankowitz, Cashman. They each want $15,000, and JAC says we are only paying $15,000 max for all of you. So it'll be interesting to see how that turns out. And before we head out, I just want to say thank you to all of the recent donations I got and super thanks I've gotten on past videos. Of course, it's never expected, but always appreciated. Thank you all so much. It really gives me just more confidence and motivation to keep going. I can't believe this has still been, we're almost about to hit 2 months, I think. So thank you all for joining me on this ride, and I'm excited to see where we go. Welcome to the Short Kingdom. If you would also like to be a royal, make sure that you remember to like, comment, subscribe, dislike if you're feeling it. Until next time.